Hi, my name is Robert Larson. I'm the owner of the Larson Law Office in Mesa, Arizona. We also have an office in Queen Creek now. And today I wanted to talk about an issue that comes up a lot in divorce and custody trials. And when that happens, people want to know if they can have witnesses come in and testify on their behalf. And of course, the answer is yes. You're allowed to bring in witnesses and have them testify for you. But the better question is usually, should you do that? And the reason I say that is because your trial time is extremely limited. And that's especially true here in Maricopa County. They don't give you very much time. And so, as a result of that, your time in court is extremely valuable. Often you wait many months before you get to trial. You go through a process where you exchange information with each other, you attempt mediation, you might have various court hearings coming up to the final trial. You might have even had temporary orders put in place. And so by the time you get to trial, you've invested a lot of time and probably money to get to that point. And the court gives you a very limited amount of time. And you're never going to have enough time to say everything that you want to say or present all the evidence that you want to present to the judge. And the judge has a limited amount of time to review the evidence and give their decision. So you don't really want to waste that time at all. And so the question is whether a witness is actually going to add to your case or if it's just going to be wasting time, because you don't want to be wasting any of your trial time. Now, why would a witness be a waste of time? Well, generally, judges don't find it very helpful if you bring in friends or family members to come in and say that you're a wonderful parent and the other parent to your children is terrible. That doesn't really help them. Anyone can get their mom to come in and say that. Well, almost anyone. And the bottom line is, I've heard many judges say that's just not helpful. In fact, when people do that on the opposite side of a case that I'm on, I'm happy to just sit there and let them say whatever they want to say because it doesn't really matter what they say. It's all I know they're just wasting time, and it's not going to be anything that influences the judge's decision. So you have to really consider that. Now, what would be a helpful witness? Uh, Usually what I tell people is if a witness actually saw something or heard something, so they personally observed something that is relevant to your case and helpful to the judge in the decisions that they're going to be making, then that would be a witness that you may want to have come into court. Like I said, you don't really want to have a witness come in and just be like a character reference. But if they saw something that is important for the judge to know, then you need to bring them in there so that they can testify about it. Because otherwise, it's just going to be hearsay, and it may not be allowed. Even if it is allowed, it's not going to have much effect because you'd just be reporting what someone else said. And so the judge really would um, find it more helpful to hear from the person who actually observed whatever the relevant evidence is. So whether maybe they saw an argument or domestic violence or drug use or whatever it is, if they've actually seen something that's specific and relevant to your case, that's what you would want to have a witness come in to testify about. Now, another part about that, a caveat is if you're the party to the case, like if you're the mother or the father of the children, and let's say your mother saw something and you want to have her come in and testify about it, well, that's really unnecessary because you can testify about it directly. So it needs to be something um, that the witness personally observed and something that you didn't observe. So, in other words, if you can testify about it, why would you have someone else come in? Judges generally don't find it helpful to have someone come in and back up your testimony either. You could do that, but you're kind of wasting time if that's what you're doing, just bringing someone in to back up what you've already said. The bottom line is the judge wants to hear from you, not from other people. Um, Another thing to think about is you can actually subpoena people to come to court. It's kind of a process that you have to go through, but it can be done, which is basically a court order. Um, the subpoena is a court order that tells someone that they have to come to court and testify for a case. Now, that's done a lot in criminal cases because people don't want to do that, and so it's pretty common that you would subpoena people for those kinds of trials. But in a family court trial, is that really a good idea? Probably not. If someone's willing to come in and testify on your behalf, then you don't need to do a subpoena because it's not required for them to testify. It's just something you do if someone doesn't want to come. So if someone's voluntarily coming to testify for you, there's really no need for you to do a subpoena. Um, and if you do have to do a subpoena, what good is the testimony going to be? So in other words, if someone has relevant information, but they don't want to come to court and testify for you, then is it really going to be helpful to send that subpoena and force them to come to court? Maybe. You have to take that into consideration. When I do a subpoena, it's usually something where it's a formality. Like, for example, caseworkers for the Department of Child Safety, or police officers, or people who work for schools or government offices. A lot of times they're not allowed to leave work and go to court and testify unless there's a subpoena. And it's not because they're unwilling; it's just that their employer requires it as a formality. And so in those situations, I'll do a subpoena. But generally, if you have let's say you had a neighbor who saw something, but they don't want to come to court and testify, is it really going to be helpful to send a subpoena and make them come to court? I guess it depends on what the testimony is and what evidence there is. But generally, in my opinion, is if someone's unwilling to come voluntarily, then why would you want them testifying for you? Because it just seems like it's probably not going to go well. Another thing you can do is you can actually schedule a deposition. So this is a very underutilized area in family court. You can schedule a deposition, which is basically where you meet with someone and you're able to take their testimony. You're able to ask them questions under oath, just like a courtroom, but you're not in court. You're just kind of in a conference room, where nowadays a lot of them are done over Zoom. And so you have a court reporter who's doing this and keeping a record of it. And basically their testimony in a deposition counts the same as if it were in the trial. So you could do a deposition ahead of your trial, and that has a few advantages. First of all, you know what the testimony is ahead of time, and you're able to present it. You can have the court reporter prepare a transcript, and then you can point out the relevant pages as an exhibit for your trial, so you don't have to waste any of your time. So that's an option. It does cost money, but that's an option if you want to be able to kind of maximize your court time. You can do depositions and get their testimony done ahead of trial, and then just submit it in the written transcript. So that's an option. Nowadays, it's pretty easy to have witnesses appear by video. In the old days, meaning anything before 2020, it was difficult, and a lot of times court systems weren't really in place to do that very well. At best, you had phone testimony, which wasn't very effective, but it could be done if necessary. But nowadays, if witnesses live in different states, most courts will allow that. If the witnesses are local, they usually want them to show up in person. But if people live far distances away, then most courts will allow that. But you have to get permission and schedule that, make all the arrangements ahead of time if you're going to do it that way. So those are a few things to consider. So like I said, you are able to call witnesses on your behalf, but serious consideration should be given whether you should or not. So the best advice I could give is just talk with an attorney and figure out how best to present your evidence at trial, because an attorney is going to be someone who's presented at dozens or hundreds of trials, and they're going to know how to prepare your evidence in the way that's most likely to get your best results. So anyway, if you have any questions, feel free to comment. If you'd like to talk to me about your case, feel free to call anytime. And if you like the video, make sure to hit the like button and subscribe if you want to get more like this in the future. If there's any topics you'd like me to talk about, please let me know in the comments, and I'll be happy to see if I can help. Thanks.